Hello everyone, my name is Raditya Hadyansyah. I'm from Rumble 5 and my name is 2508010040. So, have you guys ever heard or ever seen a country named Rwanda? So, in this video, I'm going to talk about the criminal law system in Rwanda. Rwanda is a country with a very unique legal background because its justice system was shaped not only by modern legal traditions but also by its history, especially the 1994 genocide. And today I will explain the foundation of its criminal law, its institution, how the criminal process works, and the challenge Rwanda still faces until right now. So, Rwanda criminal law system is based mainly on civil law, similar to legal system in many European and African countries. However, the system also includes traditional elements that developed after the genocides. The main legal document governing criminal law is the Rwandan Penal Code, published in the Official Gazette number 14 of 2018. This penal code defines what actions are considered crimes and what punishment are applied. Rwanda also follows the Code of Criminal Procedure, which provides detailed rules on how police officers, prosecutors, and judges must conduct investigation, trials, and sentencings. Together, this law creates the formal structure of criminal justice in the country. Similar to many modern legal systems, Rwanda follows several fundamental principles. The first is the legality principles, which mean a person cannot be punished unless a law clearly states that their action is a crime. Rwanda also applies the prohibition of double punishment, meaning someone cannot be tried twice for the same offense. Another important principle is the right to a fair trial, which ensures that every defendant has the opportunity to defend themselves, present evidence, and receive an unbiased judgment. This principle shows Rwanda's effort to build a justice system that respects human rights and fairness. Several institutions play important roles in enforcing criminal law in Rwanda. The most important one is the National Public Prosecution Authority, or the NPPA. This institution is responsible for leading investigation, gathering evidence, and bringing cases to court. Rwanda Ordinary Criminal Court deal with most crimes such as theft, assault, and fraud. However, after the genocide, Rwanda faced more than 100,000 suspects. No ordinary court system could handle such a massive number of cases. For this reason, Rwanda created the Gacaca courts, which were community-based courts that help process genocide-related cases more quickly. These courts allow local communities to participate in the justice process, encouraging both accountability and reconciliation. At the international level, the International Criminal Tribunal for Rwanda, or ICTR, handled cases involving high-ranking genocide suspects. The criminal process in Rwanda follows several steps. It begins with an investigation where police and prosecutors collect evidence and identify suspects. The next step is prosecution carried out by the NPPA, which decides whether a case should be brought to courts. Trials in Rwanda are generally public, meaning the public is allowed to observe the hearings. Defendants have several rights during the trial, including the right to lawyer, the right to remain silent, and the right to question evidence presented against them. The judge announces a verdict and a sentence. Rwanda also provides appeal mechanism, allowing defendants to request a review of their case if they believe there was an error. In addition, Rwanda has a juvenile justice system that offers special treatment for young offenders. Most punishment in Rwanda involve imprisonment, with sentences ranging from short-term detention to long-term imprisonment for serious crimes. For genocide-related crimes, Rwanda uses a classification system that divides offenders into different categories based on their level of involvement, such as planners, leaders, or ordinary participants. This system helped ensure that more severe punishments were given to those with greater responsibility. Rwanda also has special laws, including the well-known 2018 law on genocide ideology. This law criminalizes actions such as denying, minimizing, or justifying the genocides, as well as spreading hateful or divisive speech. The purpose of this law is to protect national unity and prevent any attempts to rewrite or distort the history of genocide. Even though Rwanda has made significant progress in rebuilding its legal system, the country still faces several challenges. One challenge is ensuring fairness, especially in sensitive cases involving genocide survivors and perpetrators. Witness protection is another concern, as many witnesses may feel unsafe speaking about events from the past. Access to justice also remains unequal, especially in rural areas where legal services are limited. Some people argue that the genocide ideology law may restrict freedom of expressions, so Rwanda continues to adjust and clarify this law. Despite this challenge, Rwanda is actively reforming its justice system. The government is strengthening legal institutions, improving transparency, and developing new policies to address modern crimes such as cybercrime, corruption, and human trafficking. These reforms reflect Rwanda's long-term commitment to building a stable, fair, and trusted justice system. So, that is the explanation of Rwanda criminal law. Rwanda has gone through a very difficult history, but its effort to build a strong and fair justice system show the country's determination to move forward. Thank you for watching this video. I hope my explanation helped you understand how Rwanda manages its criminal law and continues to improve its legal system until today. Bye bye.